Thank you, Ms. Kabashe. Mr. Mathebula, I'm not going to remind you each time we have had a break, but just remember throughout that you are still under oath until you have finished your evidence. Thank you. You may proceed.
Thank you, Chairman. Mr. Mathebula, we were dealing with bid evaluation committees, bid adjudication committees, those structures that take decisions. And you were explaining what the criteria are, what the prescripts are, and what the expectation certainly is from a legal perspective on what ought to happen in those fora. Can we continue along that line of the conversation, really? You have explained these committees, but can I just look at a practical example? If we look at Transnet, just by way of example, in relation to the primary decision maker there, who would it be? Because you've spoken about the bid adjudication committee, you've also said the board in some institutions, some entities has authority. So I'm just using Transnet just by way of example. What is the position in Transnet? Who takes the final decisions on tenders?
Thank you, and through you, Chairperson. Let me go back first to the bid committees.
Yes.
Yeah, because I think it must be made very clear what the prescripts say. The bid committees are subjected to ethical standards. So in other words, the prescripts talk to the fact that the way bids are structured should be transparent and not biased. And they go further on to say, if I'm sitting in a committee and I'm conflicted as a committee member, I need to declare and recuse myself from participation in any of those committees. Or even if it's a member of my family who is part of a bidding supplier, I should declare and disclose and recuse myself from participation. These are some of the ethical standards.
Can I ask you to pause just at that point?
Yeah.
What if I take a friend of mine from another board that I sit on with him or her and bring them to a board where I want certain things to go a particular way? Do the prescripts cater for that? Where friends or business partners or business people who share the same objectives in terms of what they want to do bring themselves into the same fora where decisions on huge contracts are made?
Yeah. Thank you through you, Chairperson. Look, I'm going to go back to the principle of accountability. Now, the prescripts do not allow an external person to participate in the processes. So these are government officials who must be there, because otherwise, if you allow somebody outside of government, that principle of accountability gets lost, because then now it would seem like you are now subjecting the decision making to people who are outside, and therefore the accounting authority or accounting officers would not be in a position to make a decision. That is why earlier on I spoke about the fact that even if you get independent experts, their role is simply to advise, and that's it. But they can't take part in the final decision making. But what we do pick up is that some of these specifications, it's very important, that first part of the bid specification committee. Some of the specifications are crafted in a biased manner, because that's where it begins. If that particular area is not closed, then you may as well have lost the battle, because when it goes to the next evaluation and so on, already your specifications are tainted in one way or the other. And it's a very important committee, because the prescripts also prohibit drafting specification, for instance, around a particular brand or around a particular product. The specifications must be as generic as possible, and those that participate must be unscrupulous in their conduct in terms of procuring. So there's quite a number of these ethical standards that are prescribed that all those that participate must comply with. Now, whether you're looking at the PFMA or whether you're looking at the MFMA, whose supply chain management regulations, by the way, are even more detailed than you have with the PFMA, because the MFMA is a later legislation. So at least those regulations are much broader in terms of how they should actually apply. And now getting back to the question around an example made, the PFMA, Section 51(1)(a)(3) deals specifically with accounting authorities, with public entities, because it also prescribes the same principles that are, of course, encapsulated in the Constitution of fair, equitable, competitive, transparent, and cost-effective. I mean, that's what it says. The accounting authority of a public, the account of a public entity must have a procurement system that is fair, transparent, equitable, competitive, and cost-effective. So when one looks at public entities, especially these are your Schedule 2 public entities. These are big public entities, by the way, which we now came to know as SOCs, or commonly known as SOCs. They are listed in terms of that particular schedule in the PFMA. Now, if you look at the SCM, the Treasury regulations, which were issued in terms of Section 76(4)(c) of the PFMA, that Treasury regulation, the Chapter 16A thereof, which deals with SCM issues, currently it does not cover public entities listed in Schedules 2. These are your big entities, your Transnet, your Eskom, your Denel, etc. Safcol, you name them. And also it does not apply to Schedule 3B and 3D to the PFMA. Now, the 3Bs are your national government business enterprises, and the 3D are your provincial government business enterprises. And there was a reason why in 2003, when we developed the Treasury regulations, specifically the chapter that deals with the procurement, Chapter 16A, we excluded these entities. The first reason was that these entities, have got different governance structures. That's the first thing. So they are run by boards. Now you wouldn't want to box the board of directors and prescribe to them the rules, a rule-driven kind of a system, which is typical to a normal government department. So that's the first reason. Allow them flexibility, and the rationale was they will exercise their fiduciary duties correctly in terms of the PFMA. That's one, and because they're operating as different governance structures. The second part, of course, was the fact that these entities operate along commercial lines. So bottom line to them counts, in as much as they have a developmental mandate, but bottom line complies. That was the reason why they were left out of that particular chapter, 16A, in its current form. But of course, I think I will get to this point later on during my presentation, that we are now kind of trying to review.
Yes, because my next question was going to be, how then do you monitor them? Because all the other institutions are monitored under Treasury Regulation 16 Cap A. What happens in this instance? How are they held to account for the decisions that they take?
Look, in as much as the Treasury Regulation, which is a subordinate legislation, but the primary legislation, which is the PFMA, applies equally to them. So they can't escape, because we're using the PFMA, whilst the regulations themselves exclude them, but the PFMA does not. They still need to comply with the PFMA. And as custodians, of course, of the PFMA, we play that oversight role in terms of what they need to do and the decisions that they take.
Coming back to the example I'd used earlier of Transnet, I could use Eskom, I could use Denel. Are you saying that their procurement systems fall outside of 16A?
Thank you, Chair. In the current form, yes, falls out of 16A. However, does not fall outside the PFMA. So the PFMA still applies to them equally. And we are, of course, the custodian of that instrument. So we apply it to them equally to make sure that their procurement system is fair, all those and transparent as well.
As the custodians of that system, have you had cause to conduct investigations as National Treasury into the irregularities that may have occurred in those particular entities? And I just happen to pick on three right now. It's Transnet, Eskom, Denel. There are others. I really just use those to illustrate the point.
Thank you, through you, Chair. Look, I think it's an open secret that, yes, of course, Treasury has commissioned some investigations into, irregularities, specifically in procurement of specific goods and services within some of these, large public entities.
In that instance, because this is the commission and we're trying to do a particular piece of work, are you able to tell the commission where it might get hold of these particular reports? Because by the sound of things, they could assist the commission quite significantly.
Thank you, Chair. I think we've taken a view, we've taken a position as the National Treasury that the Commission must be supported in all respects. And to that extent, all relevant reports that are in possession of the National Treasury would be provided to this committee, to this commission, to, of course, discharge its responsibility.
Is that via the DG's office or via your office?
Well, everything goes via the DG as the accounting officer. So we channel everything to the DG for consultation, and then it comes through to the commission through that particular route.
We have just touched on irregularities in SOCs and state entities, but there's of course also a multitude of problems in the other spheres of government. And I'm not exonerating national. The sense I get is that you think you are on top of what happens at national level. What is it that National Treasury does to monitor what goes on in the other spheres of government, and what steps are being taken to stem any possible abuse, any irregularities that are taking place in the other spheres of government?
Before you answer, Mr. Mathebula, please don't forget the question. I just want to say that whatever attempts may have been made during the tea break to address my difficulties in hearing counsel don't seem to have been successful. We are still in the same situation. I can hear Mr. Mathebula quite well, but there is difficulty hearing counsel. So if the problem is technical, then please, during the lunch break, try and address it. But in the meantime, we'll continue. It may be that it's not about raising your voice, but when you do raise it, it's better.
I will make a real effort, Chairman, to speak much louder. Yes.
I think what may be happening is what is natural. You would raise your voice, after some time it goes back to its normal level. But I suspect that the problem is may well be technical. It might not be your voice. You just do the best that you can without doing injustice to yourself.
It might also be, Chairman, that at my age, I think I'm speaking loudly while I'm actually whispering. So I will speak a little louder.
I don't know about the age part.
Thank you, Chairman. Mr. Mathebula, so the question really now relates to the other spheres of government.
Yeah.
How do you identify, how do you monitor, how do you try to stem irregularities that may be taking place there?
Okay. Thank you, through you, Chairperson. Look, there is a directorate, we say chief directorate, within the OCPO that deals specifically with irregularities and abuse of the system. That's one. But secondly, within the National Treasury as well, specifically within the Office of the Accountant General, there is a unit that deals with investigations. And of course, these units collaborate with law enforcement agencies, at least to deal with specific issues. The police, the Hawks, and that's a process that has existed over quite some time. So that's what we do. We do reviews of the tenders that have been awarded by other spheres, especially where allegations are raised by interested parties, and then we move in there, we collect the documentation, we assess and analyze the documentation, and eventually make a determination what could have gone wrong. And of course, I think we are enjoined by the Anti-Corruption Act to report some of these cases to law enforcement agencies to deal with, and that's what we do. But beyond, just beyond just this particular part, we also realize that there could be some gaps in our own regulatory framework, and from time to time, we issue instructions, Treasury instructions, to augment the gaps that may be existing in trying to deal with these things. And there are quite a number of these instructions that have been issued over a long period since the introduction of supply chain management in 2003 to deal with issues of the abuse of the procurement system in the country.
I do want us to talk about deviations and contract variations, but before we get there, maybe we should just tidy up the whatever evidence you may want to give this commission on the preferential procurement regulations of 2011 and the ones of 2017, and explain why you decided to publish these and whether the objective you sought to achieve has in fact been met.
Chair, through you, the Preferential Procurement Policy Framework Act, the PPPFA, was, of course, enacted in 2000, and in 2001, regulations to that particular act were promulgated by the Minister of Finance. And of course, we've spoken about the objective of the PPPFA earlier on. Now, these particular regulations, up to 2011, at least, did not apply to, again, the public entities listed in Schedules 2, 3B, and D to the PFMA. It only applies to provincial and national departments, constitutional institutions, as well as public entities listed in the Schedules 3A and 3C to the PFMA. Now, in around 2010, 2009 and 2010, there was a discussion with social partners at NEDLEC. I mean, given the procurement spend by these large public entities, to say they need to be brought into the picture within this legislation to ensure that they assist in the achievement of government social economic objectives that we spoke about earlier on. So that's one part. But the second part was to say the Cabinet has, of course, ruled that the PPPFA and the BBBEE, this is your Broad-Based Black Economic Empowerment Act, these two acts were not aligned, so they were not talking. So you had the PPPFA that went this way, and then you also had the BBBEE Act, which went that way. Now, given the importance of the Broad-Based Black Economic Empowerment Act, so then the decision was to say these two must be aligned, so that when we award the contracts and tenders, we also take cognizance of the provisions of the Broad-Based black economic empowerment to make sure that there is a transformation in the country. Now, that's the purpose why the 2011 regulations were promulgated, but that's not the only one. Of course, the other was to say the South African market was, of course, the economy was bleeding in the sense that we had a lot of imports which flooded our economy, and as a result, there were issues around job losses, etc., and some companies in the country were closing down. So when that decision was taken eventually, during the discussions with social partners at NADLEC, then we decided that that should also be part of this alignment. Therefore, the 2011 regulations introduced what we called local product, local content and production, to make sure that we favor locally produced goods, the South African proud SA goods, to make sure that we retain jobs in this country, apart from the fact that we needed to transform. So these are the reasons why we came up with the 2011 regulations. Now, if I were to answer whether were we successful, yes or no, in terms of the objectives, I would say yes, in the sense that, yes, to some degree, in the sense that the Department of Trade and Industry, together with the National Treasury, have used these particular instruments, the 2011 regulations, to designate certain goods, and certain sectors of the economy for local production. Because all tenders now that had to go out had to have at least a provision that in a particular designated product, those goods must be procured in the country. I can just give an example. If you look at the textile, if you were to go to all those instructions, the textile industry has been designated 100%. So in other words, what government procures insofar as the uniform of police, of defense people, the prisons, all that we procure in terms of that particular sector, clothing, leather, and footwear, that particular sector is designated 100% locally. So if you can't find at least the material in the country, then you have to get, of course, permission from the DTI to go and import elsewhere. But production must still take place within the country to make sure that there are jobs. So some of these sectors have been designated, 100%, like this one, some are 70%, etc. So there's quite a number of them. And we monitor together with the DTI to make sure, and of course we are also helped by the public when they see tenders that are published and without this particular condition, to make sure that at least we comply with this particular condition. That's one part, Chairperson. The second part, which I can say I can't say confidently that we have managed to achieve, is on the transformation part. Why I'm saying so? If you look at the PPFA in its current form, in the Act itself, it prescribes the 80-20 and the 90-20, the preference systems. So the public has been, of course, raising issues, and I think we're the first one within the National Treasury to admit that indeed there is a shortcoming, to say, but this particular piece of legislation does not go wide enough to address transformation. So whichever way you do, whether you try to massage the regulations as we did in 2011, but because of the fact that the 90-10 and the 80-20 is included in the primary legislation, which only Parliament can change, it was difficult to say let's move, some people would propose and say, let's go 50-50. In other words, 50 price and 50 transformational preference points. But so these are debates that at least we grappling with as we speak now, and which we hope that it would be addressed sooner than later. Of course, we've heard South Africans, we've heard what they're saying, and we're taking a position to address that particular issue. So whether you have the 2011 regulations, but you're still sitting with this 80-20 and the 90-10 that sits in the primary legislation, because you can't change the primary legislation through the subordinate legislation. So that's the challenge that we're having currently. That's just the one part that I think we still have got a long way to go to make sure that we live up to what the broad-based black economic empowerment, requires of us to do. Now, just lastly, I think I must also state that the BEE Act talks to transformation of sectors and, of course, industries, and also the patterns of ownership in terms of the business in the country, whereas the PPPFA addresses preferences. So we allocate preference because you are a level 4, a level 3, or a level 2, a company, or a level 1, etc., etc. I mean, these are some of the things that we're grappling with, but I'm sure in no time we will be on top of this particular challenge.
I have focused quite a bit on your oversight role and your monitoring role. But I know in terms of the PFMA, you also have an enforcement role.
Yes.
And that's also of interest to this commission. How do you implement that role? Because it would appear that very few people suffer the consequences of the transgressions that have come up in the public arena, in public debates. So enforcement, talk to us about enforcement of these prescripts by National Treasury. And maybe you should just break it down for the chairman. Maybe we should look at national, the 3 spheres, and then if you could then deal with the entities as well as a separate category. What is your role in terms of enforcement?
Okay. Chair, Section 6 of the PFMA is quite clear on the roles and responsibilities of the National Treasury when it comes to enforcement. And the same provisions of Section 6 are repeated in Section 18 of the PFMA for provincial treasuries to assist in terms of enforcement. And also the MFMA, has provisions to make sure that the National Treasury enforces this piece of legislation. The powers of the Treasury are quite clear there. As indicated earlier on, where we pick up gaps, especially where there are irregularities in the system, we issue instructions to augment the system. But the question is, are instructions on their own enough to address some of these things unless you address the behavior of the people that are dealing with procurement to make sure that they live up to what the Constitution is saying. We have, of course, a number of divisions within the Treasury. All of us together enforce certain parts of the PFMA and the MFMA. However, there still remains a challenge. I must say that a challenge, it's a war that we're fighting to make sure that there is no abuse of the system. But of course, as you may know now, that there are still these elements much so embedded in the system for intentional abuse of the system.
Yes, which is why the question is, where you recognize and identify
Yeah,
that intentional abuse of
Yeah.
the system,
yeah.
what steps do you take? You can use any example to illustrate the point. What is it that you take? And the reason this is important is because the chairman at some point will be making recommendations on a variety of things.
Yeah.
Maybe this is an area that this commission needs to explore in detail, so that when recommendations are proposed to the chairman, he has an appreciation of where the problems sit.
Okay. Chair, in terms of our action, I mean, we've done this over the years, even during the State Tender Board, save for the fact that the State Tender Board was inconsistent with the Constitution. So when we pick up abuses of the system, there are processes prescribed in terms of the public service regulations to deal with officials, because the accountability vests with accounting officers. That's one process. To take disciplinary measures and so on against the perpetrators. That exists. But the second part is when we pick up that there is a problem, we have one of the following. We investigate, we cancel the contract. Of course, you apply rules of national justice. Cancel the contract. We also restrict, in extreme cases where there is, we restrict suppliers from doing business with government. I know in the past, during the State Tender Board era, some of suppliers and even persons individually were sitting in our restricted list indefinitely, because that's what the State Tender Board Act says. We could restrict you indefinitely, which I think was a bit of a problem, because there is no individual person that must be sanctioned to perpetually. So, but currently what we do, because we take our cue from the Anti-Corruption Act, the Combat Anti-Corruption Act, at least it sets a limit in terms of the period, for which a particular supplier or individual must be restricted from doing business with government. Now, there's a shortcoming though, that's one part. But there's another part that has to be sanctioned by court. So there are two lists. There is one list that, as National Treasury, we put together and we place people there. That's one list. But there's another list called defaulters, those that default. But that, of course, has to be sanctioned by court, because we pick up this information, we send to court, and court would then endorse and say that particular supplier and those people must be endorsed on the register for defaulters. Now, there is a slight challenge in both processes. We are not experts, especially when it comes to the register for tender defaulters. We are not experts in sentencing. So courts have at times simply said, no, it must be endorsed, but they don't, of course, indicate for how long. Now we sit and we decide, which I think that's what, and we decide out of our own to say, I mean, the transgression may be, I mean, the sanction may be commensurate with the transgression. And then we decide we give you 5 years. For 5 years, you are barred from doing business with government. But whether that is fair we don't know. So, but that's a shortcoming in our process for both restricted list as well as where court sanctions and endorses that people must be on that list. So we would prefer at least a system, I'm sure, where at least courts take both this responsibility of endorsing as well as sentencing, to say for how long. But the Anti-Corruption Act at least is a guide in our case because it says no more than 10 years.
Now, in the response you've given the chairman, I understand that within the 3 spheres of government, does the same response apply to SOCs and other state entities? Are they monitored in the same way? Do the same enforcement rules apply to them?
Yes, it is correct, Chairperson.
Which particular office within National Treasury keeps a schedule of these transgressors? Do you actually keep a record, an annual record of what you've investigated, how many people have then been prosecuted, or what enforcement measures have been taken against particular people?
Thank you, Chair. Those that are investigated by the Office of the Accountant General are kept by that office. And those that are investigated by the Office of the Chief Procurement Officer are kept by that office. So the stats in terms of what happened, we keep differently because the OAG also receives quite a number of and they're involved in quite a number of investigations, similarly to ours.
And then just to recap, you have suggested that we speak to the DG in relation to getting these reports, because he can then coordinate the various sources of reports, whether it's statistics or any other investigative reports.
Yes. Yes, Chairperson, that's correct.
Can I then move to the question of deviations? Deviations form a substantial part of your statement.
Yes.
And deviations and variations and expansions of contracts really are 2 sides of the same coin in a sense, because they're again another weak link in the manner in which procurement is monitored by yourselves. Please address the question of deviations as fully as you can and deal with the exceptional circumstances. But in doing that, deal with the deviations from those exceptional circumstances, if I might use the same term.
Okay. Thank you, Chairperson. Deviations are actually allowed in as much as Section 217 says, but practically, there are instances where, organs of state are allowed some kind of degree to deviate from the procurement processes. But then there are instances, the first instance is it must be on an emergency basis. For life-threatening situations, cyber security crime, which threatens national security, fire, and all those instances are classified as life-threatening. So you can't be expected to go out on an open competitive period over 30 days to make sure that you address that particular issue. That's an emergency. That's how we define emergency. Then you are allowed to deviate. But
Can I ask you to pause there? Is
Yeah.
it defined in the prescripts?
Yes.
Which particular prescripts?
This is defined in Treasury Regulation 16A 6.4 and also in the MFMA, as well as in a number of instructions that I will talk to.
But would those apply to those SOCs who we earlier agreed are not governed by Treasury Regulation 16 Cap A?
Yes, Chairperson, they would apply, and I'll explain why, if you allow me. So the first part is emergencies. The second part is sole source statuses, where you are allowed to dispense with a competitive bidding process. It's a sole source. I mean, in this country, it's a known fact that over a period of time, we procure electricity from ESCOM. So why would you expect an open competitive? There is one supplier for electricity in the country, and therefore it's ESCOM. So in those instances, the prescripts do make provision for dispensing with a competitive bidding process. Now, when we made this provision in the Treasury regulation, immediately thereafter, we then pick up pockets of the abuse of this particular regulation. And we issued an instruction to say, look, if you deviate from a normal procurement process, other than in case of emergency or sole source, and the transaction is above $1 million, please report to the AG within 10 days. And also the reasons for deviating from a normal procurement process must be recorded by the accounting officers for audit purposes. That's one instruction. But this thing, went on. People started to make use of this because, I mean, that's an instrument that's there. Then we again issued another instruction that prescribed certain thresholds within which people could apply this particular provisions, and not losing the fact that it's on the basis of emergency and sole source, not agent. Because I know some institutions would always say, no, this is agency, confusing emergency and agent. And agency. And in recognition of the fact that you would find instances where a contract starts at 4 million, and by the time you know it, the contract value is sitting at 200 million, and you ask yourself, how is this possible? Then we issued an instruction in 2011, May 2011, to deal specifically around these issues, where we're prescribing exactly in what instances should contract expansions and deviations be allowed. In the case of the expansions and variations of contract, we then prescribe that for your normal goods and services, a contract could be varied by 15% or 15 million, whichever is the lesser. Okay. And then for construction-related procurement, we set the threshold at 20% and 20 million, also whichever is the lesser of these amounts. So that was an instruction that we issued in 2011. Of course, the instruction issued in terms of Section 76 4C of the PFMA. Then, in 2016, there was another instruction that we issued, 2016-17, to combat procurement abuses. And this particular instruction also highlighted exactly the same principles, save for the fact that this particular instruction went a step further and say any other deviation outside of emergency and outside of a sole source must be approved by the relevant Treasury. when relevant treasury would refer to national treasury and provincial treasuries. And I think the intention was quite good because you wanted to make sure that all deviations come to treasury and the relevant treasury approves. That was the intention, to combat. And the second intention was to make sure that the system becomes transparent, because already we knew that in as much as some of the public entities were not covered by our regulations, but these practices were happening in any event. So, but there were unintended consequences. I think this is quite important, in the sense that instead of deviations being an exception from the norm, deviations became the norm. So, organs of state, instead of complying with Section 217, saw a room to use deviations to circumvent the system. And this is where the challenge is. Remember, deviations by their very nature, if you say to me, I must deviate from a normal procurement process, you're actually giving me a blank check. Because then I decide, who do I award the tender to? It's given to me, I decide, I can give it to anybody. I think that's just the unintended consequence of a very good intention in terms of that instruction. So I think, let me stop here for now in terms of deviations, Chairperson.
Who has kept a record of those deviations, if there is one at all?
Thank you, Chairperson. The Office of the Chief Procurement Officer keeps the record thereof, and all deviations approved or not, supported or not supported, are published on our website. So it's a publicly available information on our sub. You can see which entity applied for which deviation, and what was granted at the end of the day, and even the estimated value of a deviation, because deviations are based on a project or a contract. And that information is readily available. We provide it from time to time to Parliament, of course, and it is a published information. It's available.
Back to the question of enforcement. What do you then do where you have found deviations that are outside of the prescripts of National Treasury? Consequences.
Before you answer, Mr. Mathebula, just so that in case somebody has done something, then they know it's working. Right now, I can hear you very well.
Thank you, Chairman.
Yes, you may answer.
It's enforcement consequences. We go back to that question.
Yeah.
What happens to those transgressors?
You know, it's one area, Chairperson, because when we report to Parliament, and then Parliament plays its oversight role, you may have seen that a number of these entities and government departments over the last while have been appearing before Parliament for consequence management, because that's what Parliament is there for, to play the oversight role. We go to Parliament, of course, to support Parliament in its work when these departments and entities are hauled before Parliament to answer to some of these things as we speak. It's an ongoing process to make sure that there are consequences.
Again, I simply go back to the state tender board because it's a regime that we had and that one can use just to compare where we are. Variations of contracts, deviations. How were those dealt with under that regime? And you can see my train of thought is I'm already thinking, is there anything that this commission can recommend in terms of strengthening and improving the prevailing framework?
Thank you, Chair. The State Tender Board, as indicated, also did deal with contract variations, but to reasonable degrees. Because the board would simply say, okay, if there is an application for a variation of a contract, firstly, the board would ask questions. Why was there variation in the first place? Because government departments are supposed to plan. So lack of planning, of course, should not be used as a reason for varying contracts. So it dealt with those issues, but very carefully, in the sense that the State Tender Board would simply say, okay, we're giving you a variation, but based on certain conditions that institutions had to comply with. I know they would, for instance, they would say, we're giving you this on a month-to-month basis, but not exceeding X amount of period. So within that period, so in other words, your contract extension should be on a month-to-month basis, but not exceeding X period. If for whatever reason, departments failed to comply with that, they could either come back to the board, provide reasons, or the contract expires, and then the department would be sitting without, and then they were given what we call delegated powers, where they could procure through their own delegated powers, which of course were delegated to them by the State Tender Board, pending the finalization of their own contracts. And the board would always follow some of these contracts, because remember, all procurement was under the auspices of the Tender Board. So there was a record of what has happened, what decisions were taken, have those decisions been implemented, et cetera, et cetera. But that was the position in that particular. So again, the delegated powers within which government departments had to comply with conditions set by the State Tender Board had thresholds, had limits in terms of thresholds. The board would say, okay, we're delegating you, but not more than, as an example, 750,000. But those thresholds were set out quite clearly in the prescripts of the State Tender Board.
What I understand you to be saying is that there were much tighter controls, really, probably because the State Tender Board system was centralized and it was easier to then monitor and tighten controls over spending. Or would that not be a fair summation?
Look, Chair, I think in hindsight, when one looks back, the existing framework is now in the system for more than 10 years. I think we introduced this in 2003. We are now in 2018, so we're talking 15 years at least of the current procurement framework. I'm sure one can always, in hindsight, say, yes, perhaps there was a reason to stay with the State Tender Board, but I cannot say convincingly that the board also did not have these elements, because there were also allegations against certain board members and their influence in terms of where procurement contracts should be going to. I think that's one of the reasons to say, based on these, because these are board members, of course, and they live within communities, and they are not immune they were not immune at that time to some kind of influence, as is happening currently today. So, but at least there was some level of control at the time. Apart from the fact that the service delivery was very, very slow. And I think is quite important. Service delivery was impacted negatively, quite negatively, and quite very, very slow in terms of the decisions of the board.
Yes, you do make that point. Maybe this is an appropriate time for you then to deal with the reforms, the revisions that you are considering as National Treasury. You'll find that section on page 33 of your statement, and you break it down in your statement. So if you could just help the Commission understand what measures you are taking to correct what you have identified as a project gone wrong.
Okay.
Those elements of the project that have gone wrong. I'm not writing off the whole system, just those elements that have gone off the rail.
Thank you, Chair. Through you. Now, earlier on, we spoke about the complexity of the system, of the current framework, and we also spoke about the fragmented system, how fragmented the system is, where you have the core piece of legislation that are supposed to deal with procurement, but you also have a number of other pieces of legislation that have an impact on procurement. So in recognition of that problem, and also in recognition of the abuse of the system which exists currently, as the National Treasury, we are reforming the system. There is a bill, a public procurement bill, that would be a national overarching regulatory framework to deal with all these other pieces of legislation. So some of these pieces of legislation would be repealed through this bill, some would be amended. There could be some amendments to make sure that you have one legislation in the country that deals with procurement. Whether you have people coming outside the country or in the country, but when you come to South Africa and you say, what is the procurement legislation in the country, we can then point out and say, this is a particular piece of legislation that deals with procurement process in the country. Now, the process is at an advanced stage, and of course, one of the issues that this bill will deal with is will review the delegations of authority. Will also strengthen procurement planning, because I think that's where the problem is. There are also governance issues, because the failure of the system lies in governance, compliance, and so on. And we're also providing for the alternative dispute resolution mechanism. Chairperson, we don't want to always appear before courts to save costs. I'm sure we can have another system where we think it is. I mean, that's provided for in the bill. And then also the Treasury regulations themselves are in the process of being reviewed, and they will be published soon for comments. Because if you look at that chapter 16A that I've been always talking to, it recognizes your normal goods and services, but it does not address the procurement of infrastructure, and which is quite a huge spend in terms of procurement in the country. It does not address those processes, and it also does not address the procurement of capital projects, which you see currently. You have power stations that are under construction in the country. I mean, that's capital. So that's what this particular piece of legislation seeks to do. And of course, to strengthen governance issues, as I indicated, and to make sure that it gives more powers to this office of the Chief Procurement Officer to play an oversight role and take action where there are infractions and abuse of this system. Currently, for instance, when accounting officers, for some reason, because they answerable to the ministers, so you can go that route and say, no, for me to deal with an accounting officer, at least you channel that through the minister, because that's the minister's responsibility in the current system. And I think it will remain as such for now. We don't want to make sure that there's a, but at least insofar as the transactions themselves, which are irregular in the process, we have much more powers to deal with those, take decisions, and where necessary, restrict people from doing business with government. So that's what is in this particular legislation. Also, the strengthening of contract management, because this is where, when we're talking contract variations, which is a very serious issue in this country. If you enter into a contract and the contract is 3 years and all of a sudden the contract finds itself being extended up to 12 years or 10 years, it can't be. You can't allow that to happen. Because firstly, it creates the so-called evergreen contracts in the system. And it also serves as a barrier to entry by small, medium enterprises and also black-owned companies who find it very difficult to penetrate. And it also plays itself to the anti-competitive practices, collusive, cover coating, you can name them. And also the principle of value for money gets lost. And what is also most important is the risk that one takes to extend a contract. For instance, if an application to vary a contract is submitted, and you don't even know how this contract was procured in the first place, you're coming right at the end, you don't have all details of what happened, and then you extend this contract. Contracts get extended time after time, and this is also one area that I think we need to tighten very much to make sure that we improve contract management so that there's proper planning. When contracts are about to expire, government officials, those that are involved in procurement, embark on the procurement processes to make sure that we live up to the Constitution and to other pieces of legislation to make sure that there is transformation in the process. And it's an area that is also very much in our radar. The bill, of course, has to go through the normal legislative processes, and it will be published soon as well for public comments. I mean, this is what we've always been saying. And once Cabinet approves the publication thereof, we expect South Africans to submit comments. And it's quite urgent that we finalize this process. That's how urgent it is. And I think even at levels outside ourselves, there is an agency. Government is placed, this is part of its priority projects to make sure that the public procurement bill is out there, and then people can have an opportunity to comment and also to address all these other socio-economic objectives that we spoke to earlier on.
I understand what you're saying, but my next question is, how is Treasury going to build this capacity that you speak of? Because you speak to capacity in contract management, you speak to capacity in procurement planning, just by way of example. What practical steps or measures are you able to take to build this capacity?
Thank you, Chair. There is a process within Treasury currently to build capacity. There is again a division that's responsible for supply chain management capacity building. And of course, I think there are two streams there. The one stream is to professionalize this profession. Because currently, as I indicated earlier on, you can just take anybody and throw him there and say, go and procure. That's where the problems are coming. So to professionalize, to make sure that, and why professionalization? Professionalization to make sure that, like in any other profession, if Mathebula is found to have flouted the processes, then the body that is responsible for that particular profession must take an action against Mathebula and say Mathebula must be struck off, just like in any other profession. So that's one part, to capacitate. But the other part, which is an agent part and practical for that matter, is really training and development. Because practitioners must be able to put together a tender document. That's what is lacking. Hence, we always appear before courts and so on, simply because the way our tender documents are crafted, you could clearly see that all these laws that we're speaking about, there is a lot of misinterpretation and so on. Hence, we land into the problem. So the immediate step that Treasury is taking is to make sure that we train people practically to put together a document that complies with the Constitution and all other applicable legislation. So that's one part. But the professionalization, we're talking to tertiary institutions, is much more long-term. And we also have a partnership with the National School of Government to make sure that we train people. We have also the forums that we always have, where we share information among ourselves as procurement practitioners in order to clarify policies, etc., etc. It might not be adequate, but it exists as we speak now.
As I conclude, can I ask you to apply your mind to the next few set of questions? The first is, you have told the Commission that the procurement spend of government is in the region of 800 billion. Is there a monitoring process to ensure that this money spent achieves its intended objective?
A difficult question, Chair. Quite difficult. But look, the whole process also talks to the public finance, the management of the budgets after the tabling of a budget by Minister of Finance in Parliament, that all of us, all divisions within the National Treasury, are enjoined to make sure that government departments and public entities spend that money correctly. But of course, there is a challenge. There is a challenge because we can't claim that all this money goes to where it is directed to. Hence the problem that we're facing in the country.
Then my next question really is one that seeks to identify the real where the problem really is located, these transgressions, the misspending of money. Is it the law that needs to change? Is it government policy that needs to be revised? Or do wrongdoers simply have to face the consequences of what they have done? Where do you locate? And I know you've spoken to us about reforms. Where is the nub of this problem?
Chairperson, I think it's a combination of all this question. If you look at our regulatory framework, as indicated earlier on, that for quite some time, some of our prescripts never applied to specific public entities, which we've now corrected, of course, through instructions. That's one. But also the bigger element is the human element in this process. Regulations are there. Hence, we augment them from time to time. But humans must also choose to make sure that there is compliance in the process. And of course, the issue around investigations and subjecting people to prosecutorial processes is well known, save for that maybe the processes at times take long in the current justice system. This is personal now. This personal, it's got nothing to do with the prescriptions. That perhaps we may need to look at whether we shouldn't reclassify procurement transgressions differently so that they get fast track, or even considering a special tribunal specifically to deal with these cases. Because otherwise, if you don't do so, then the road continues in the system.
Yes, in fact, this is also one of my last few questions. These criminal prosecutions, investigations that have taken place, maybe I should rephrase that. You have investigated certain matters and referred them for criminal prosecution. But once you've done that, you have no control over what happens to those transgressors. Is there anything that you are thinking through? Because really, you need to have a deterrent to malfeasance, an effective deterrent to malfeasance. Is there anything else other than these referrals to prosecution that you are knitting into your reforms, over and above the items you've already mapped out to the Commission?
Chairperson, I'm sure we can always take recommendations of what else could be done, but obviously we've always maintained a position that we need to send a shock in the system. And of course, the current instruments that we're using, where we bar people from doing business with government for quite some time. But of course, the other part is that criminal part where people should be subjected to. But we are open to any proposals that we can include in our procurement processes for improvement.
Mr. Mathebula, are there any other material issues you would like to raise with the Commission within the context, of course, of public procurement?
Chair, except for saying that we will continue to serve and where we identify wrongdoing, that we make sure that the wrongdoing is dealt with. And of course, also to make sure that are people who were historically disadvantaged, by unfair discrimination do benefit from the procurement of this country. And I think we can say that without any fear that it has to be done, but of course within law. That's what we say. We need to advance them. Must be transformation, and people must repent at some point in time. I think this is where I will leave it for now, and thank the opportunity to appear before the Commission.
Not quite, Mr. Mathebula. But thank you very much. Chairman, there may be questions that you wish to put to Mr. Mathebula.
We are going to take, if you are done, the lunch break, because we are on my watch about 7 minutes before 1, and Mr. Mathebula must come back at 2 so that he can clarify certain things. You are done.
I am done, Chairman. Thank you very much.
Okay, thank you. Those who may have done something that has improved the situation in regard to my problem of hearing counsel, I think if they could do the same in regard to the witnesses' mic or speaker, it would be helpful. I can hear him, but if I can hear him as well as I hear counsel, that would be great. We'll adjourn then until 2 o'clock.
All rise.